It's time for a coffee break, which means it's the perfect time to hear some experts give their takes on financial crime. So pour yourself a cup of joe and tune into your new favorite show, Coffee Breaks.
Welcome, everybody. Thank you for joining us for our Coffee Break series. Today, we're going to talk about a specific provision of the new, not so new anymore, Anti-Money Laundering Act of 2020, the provision dealing with subpoenas of foreign banks. And with us today, I'm Alma Angadi. I'm a partner at Guidehouse, and I will let my esteemed panelists introduce themselves.
Thanks, Alma. I'm Deb Thorne-Peden. I'm a partner over at Pillsbury, Winthrop, and we're really honored to have a chance to do this with Guidehouse today.
Patrick?
And Alma, esteemed panelist might be a little strong. I'm just a guy from California who happens to live in D.C. now. I'm Patrick Overkemian. I'm at Pillsbury, Winthrop, Pittman here in D.C. I was at DOJ for about 7 years beforehand doing transnational crime, anti, not pro, and the prosecutor in California.
We're so glad.
So it's great to be here.
Yeah, we are happy about that, Patrick. Glad you're on the side of the good guys. Deb, why don't you kick us off?
Sure. So the AMLA, or the American Money Laundering Act of 2020, was enacted last January 1st by Congress, and certainly I think has some of the broadest provisions and changes to the anti-money laundering laws in the U.S. since the time of the Patriot Act. In terms of our subject today, the changes on the foreign subpoenas and the powers that the U.S. has had expanded under this law are really significant. So what has happened with the new law, and this is already effective, is it allows the U.S. to reach any foreign bank that has a U.S. correspondent account, and it allows the Department of Justice and Treasury to issue a subpoena to any foreign bank with a U.S. correspondent account, and not only request records regarding that correspondent account, but they can also ask for information on any account held at the foreign bank, regardless of whether the records are in the U.S. or elsewhere, that are the subject of any of the following four items. If there's any investigation of criminal law in the United States, any investigation or violation of this section of the AMLA, a civil forfeiture action, or an investigation which addresses special measures for jurisdictions, financial institutions, international transactions, or types of accounts of money laundering concern, a primary money laundering concern. So what's really important about that is the extreme reach of it, and it's clearly not limited anymore to just money laundering matters. It is broader than that. Now, certainly the government has to meet certain standards to issue one of those foreign subpoenas, but it really is a pretty amazing breadth in terms of the scope of what can now be demanded. And as we'll go through, it's got some very significant penalties if that's ignored. So, Alma, do you have some thoughts in terms of sort of, immediate takeaways on this?
Yes, thank you, Deb. So I think some things for financial institutions to think about, is even as we go through the details of this. As you said, this is already in effect. We don't know if anyone in the Justice Department has used it or tried to use it yet, but it's already in effect. A lot of the provisions of the AMLA don't go into effect for quite a bit of time, but this is here now. Some things that the financial institutions are going to want to think about doing right away. There maybe have to be some contractual provisions in their correspondent account relationships that they've got to change or they've got to look at. They're going to have policies and procedures in place to deal with this if it happens. You don't want to be running around scrambling if you get one of these. And you probably want to maybe even do a tabletop exercise in who gets informed, how you deal with it. Do you talk to your counsel? Those sorts of things. And it might not be a bad idea to check your very high risk foreign bank clients to make sure that you're actually still comfortable with that risk given this this provision.
And I know for some of our clients or potential clients, we're getting calls from some foreign banks. Not that they've got a subpoena of this nature yet, but they want it to be prepared in the event that they got one and sort of, set things up ahead of time, which may or may not make sense for different banks.
Exactly. And so it's important to think about, I think, what's different about this is that the U.S. government could always subpoena the records dealing with if you are a foreign bank, with your account in the U.S., right? That correspondent account with ties to the U.S. and certain limited records maintained outside of the U.S. But this is much broader, and it will be interesting to see how and when the Justice Department decides to use it, considering you are essentially reaching financial institutions anywhere in the world for documents that have nothing directly to do with the United States. So, Patrick, it might be good for you to talk a little bit about why we're doing this, why now, and how you think, in which situations you think that the government will use this.
Yeah, so the short answer, I think, why now? Well, I've never met a government agency that didn't like more power, right? More ability to look at things from different angles, more ability to get evidence, more ability to build cases. And look, this was an issue. I think there was a kind of a feeling that these correspondent accounts existed. They're, legitimate business purposes, but sometimes lots of money was going through them, and U.S. law enforcement and other authorities didn't necessarily have the greatest insights and sightlines into these accounts. And Congress got together and passed this law, which, I have to keep straight in my mind. It's AMLA, but if you transpose the L and the M, you get ALMA. So
you do.
Panelist ALMA, I missed this. It's my bad. My preemptive apologies for it.
No, I do it too sometimes, sadly. Yeah.
But look, it's not only about more power, right? It's also, about combating some serious offenses, money laundering being key among them. Of course, it's in the title. But it's never just about money laundering. It really isn't. The underlying offenses and related offenses are really at issue also. So I, again, come from the context of having prosecuted transnational crime, for example, and that can encompass everything from terrorism to corruption to fraud to human trafficking to drug trafficking, and even the opioid crisis, right, which has kind of plagued the country for a while now. Senator Brown, who I think is on the Senate Banking Committee, he made some comments around the time when this was passed, and he said things like, money laundering isn't a victimless crime. It impacts all of us. And he listed the various areas in which it impacts, prosecutions in the country at large. And for example, he cited his home state of Ohio, and he says that money launderers fuel opioid use and human trafficking, right? So, again, I cite those, not as anything other than just to say, I think Congress intended this law to be broad. They recognized a problem or a number of problems that existed, and did their best, by their account, to give law enforcement more tools to tackle those problems. But as you pointed out, it's we haven't really seen how it'll be implemented yet, and I guess time will tell.
And we have heard from other Justice Department folks in the Justice Department that there's a big focus on AML and sanctions cases with national security implications. And you can see hints of that with FinCEN's focus on ransomware, for example, and with very specific sanctions applications coming out of OFAC. And so it wouldn't surprise me if this is tied up with that. Now, let me ask you guys, is this going to be, do you think we'll use this with friendly countries or countries we're not so friendly with? Like, I could imagine some allies getting a little annoyed if we're asking for information like this, subpoenaing information like this, unless we're working with them.
Hard to say. I think it will be up to what the government wants to do. And I one would speculate they'd use it more with countries that are maybe less friendly. But if you've got a large case going on, if they want access to the information, and if you think about it, Alma, think about even some of the tax cases that have come down, right, and access to information there. And many of those accounts are certainly in friendly countries as well. So I would speculate, where they think it's appropriate, they will use it in any country for any foreign bank that they want to cover. Patrick, do you have a different view?
I don't have a different view, and I don't want to lead on to our viewers and listeners that this is scripted in any possible way. But we will maybe be talking later on about, the AMLA process and the DOJ's Office of International Affairs and the role that they play. And I can talk about that a little more then, if that works, Alma.
Sure.
But the short answer is I kind of concur, with Deb. I think, time will tell and we'll see. And again, go back to first principles. Government agencies like having more power, and we'll see. I mean, it's sort of a to be determined, but I think it's perfectly reasonable to predict that it'll be used in different substantive contexts with both kind of allies and less friendly countries alike.
So, Deb, do you want to walk through some of these other provisions? Because
Sure.
The details of this statute are actually quite interesting.
Scary is another term for them, but yes. Why don't I touch on the law has basically a prohibition for the foreign bank to notify any account holder involved or any person named in the subpoena of the fact of the subpoena, but it's not just the bank. That prohibition runs to the foreign bank, its officers, directors, employees, no big surprise there, but it also runs to their partners, shareholders, agents, and attorneys. And it's almost like the SAR prohibitions where you just absolutely cannot give notice on it. And violations of it are significant because a violation of that notice provision under the law can result in penalties of double the amount of the suspected criminal proceeds sent through the correspondent account. So, if you're giving notice on one that has millions and millions and millions of dollars that have run through it, it's potentially double that if somebody gives notice. If there is no monies that are running or suspected criminal proceeds running through a correspondent account of the foreign bank in the related investigation, they can be tagged with a $250,000 penalty. So this notice provision is really significant. And actually what I think is equally interesting, because as you know, I'm in addition to anti-money laundering law, I do privacy law too, is sort of the first thing that came to my mind was, could you challenge it on a privacy ground? And the law itself provides that although a subpoenaed bank can seek relief on the notice provision of the subpoena that we've just been talking about, but they have to do so before the return date on the subpoena, which I don't think is going to be very long, so it's probably a very quick action. And they have to petition in the U.S. District Court for the judicial district in which the related investigation is proceeding, so they can't go through other courts to try to modify or quash the subpoena, or at least that seems to be the intent of the law. And although there's possible grounds that you might be able to claim that it's too burdensome or too indefinite or possibly a lack of jurisdiction, but the statute specifies that asserting that the subpoena would conflict with foreign secrecy or confidentiality laws shall not be the sole basis for quashing or modifying the statute. So in other words, even if you've got one heck of a privacy law in another country that would prohibit this, that cannot be the basis, or at least the sole basis on which that U.S. District Court can quash this by the federal statute itself. So that I thought was a pretty unusual provision as well. Sort of reminds me a little bit of some of the NSA,
Yes.
Subpoenas that came out too.
That could put the foreign bank in a heck of a spot, right?
It does, because if their privacy laws prohibit giving this information out, the U.S. laws are basically going to say tough, or potentially, and if the foreign bank is saying we've got to notify them, they've got immediate triggers in terms of even just giving the notice, much less the failure to comply with the subpoena, where there are additional potential penalties that can apply.
So, Deb, do you foresee this being kind of a hot area potentially for litigation and parties, actually trying to get the metes and bounds of what the law actually requires and what the courts will force them to do?
Well, yes, I think particularly if you're a foreign bank and you think, especially if you're viewing the nexus to crime being more limited, or again, if they've got extremely strong privacy laws that they would be violating, those banks may feel like they're between a rock and a hard place and that they're going to have to try to challenge it. But again, they're going to have to come up with something more than just the privacy issue. They're going to have to try to fight that subpoena, and again, possibly to burden some other grounds. But that is a pretty interesting limitation in terms of and requirement for foreign banks. Patrick, do you want to talk a little bit about service of the subpoena?
Sure. So the subpoena itself will say, what the return date is, the judicial district in which the related investigation is proceeding, kind of typical subpoena stuff, right? And the law also says it can be served in person or by mail or by fax in the U.S. if the foreign bank has a representative in the U.S. Or, if applicable, in a foreign country via an MLAT, a mutual legal assistance treaty, or other kind of multilateral agreement or request for international legal or law enforcement assistance. So that's in the statute, and what's also in the statute is what the penalties are for failure to comply. So Alma, I don't know if you want to run through those.
Sure. I mean, as Deb said, the financial penalties for violations of various points of the statute are pretty significant. $50,000 per day and additional penalties if noncompliance continues beyond 60 days. Court can issue orders to compel, including but not limited to contempt. But I do think the real nuclear option penalty in this is that the DOJ and Treasury can order a U.S. bank to terminate the correspondent relationship within 10 days, 10 business days. Now, I've helped banks wind down correspondent relationships voluntarily, and it is difficult to do in 6 months, much less 10 days. It will also, depending on the country where the foreign bank is and what kind of transactions are going through that correspondent account. Presumably, they're not all criminal proceeds, although I guess in some cases they could be. But it's going to be incredibly disruptive, potentially, to that country's economy, because the U.S. dollar is the business of the world does business in dollars, and so it could be incredibly disruptive. So I think that is really the one that could be incredibly disruptive.
Well, that plus it not even just that, if depending upon the corporation that's involved, right, underlying the correspondent bank, if it's international corporation and that's maybe their only correspondent bank account in the U.S., if it's shut down, it's going to take them time to possibly find a new correspondent bank, but it might also cut off a large portion of their business.
Exactly. And that's going to be one of those practical things for U.S. banks to figure out. How do you close a correspondent account in 10 days, right? Because if they don't do it, they're in trouble for up to $25,000 a day that it fails to terminate that relationship. So there's going to be pressure coming from all sides on this, plus notifying the board that this is happening. There's just a lot to have to go on.
And it seems like the trigger on these subpoenas is very short in terms of timeframes. As we were discussing, to even try to quash it, they'd have to file in the U.S. District Court in the U.S. that's overseeing the investigation. There's very tight timeframes in terms of how quickly you've got to turn it around. As Alma was mentioning, if that foreign bank fails to comply, the U.S. bank can be instructed to shut it down, and they're instructed to shut it down in 10 days. They don't really have much choice. It's a direct order for unless they can somehow try to get the judge to give them more time. But other than that, it's going to be pretty extraordinary. It's almost like a sanctions law in its own way in that capacity. It's effective and people are going to have to act on it. Yep.
And so it might be good to have conversations with your U.S. counsel, if you are a foreign bank, to figure out how you're going to approach these, right? So you're not scrambling too much. Before we continue, I'm going to put our nifty slide next as you guys continue to talk about. There it is. We kind of did a little workflow on how this might work. And starting from the beginning, Patrick, let's talk about what you mentioned before. How is this going to come up from a procedural matter within the Justice Department? And then we can talk about some of the other, things that are going to happen.
Yeah, so the short answer, Alma, is we don't exactly know yet. And that's kind of true about a lot of provisions of this law. But what I will say is there is this riveting manual called the Justice Manual. It used to be called the U.S. Attorney's Manual, USAM. It has recently been changed to the more aptly titled JM, Justice Manual. And in the Justice Manual, you will find any provision that you could imagine that applies to the department and its conduct of prosecutors. So one of the provisions in there talks about what is needed before issuing a subpoena for records located abroad during a criminal proceeding, right? So for those at home who would like to look it up, it's Justice Manual section 9-13525. And again, I checked before this webcast. It hasn't been updated yet. So the last update was in, I think, 2018 or something like that. So I think we're still current. We're good. But basically what it says is the DOJ's Office of International Affairs, which is a component of the criminal division of the Department of Justice, has what we call, or what I in my former position would call prior approval of subpoenas issued in this context, right? So there's a number of different requirements the Justice Manual can impose. One is sort of like a consult requirement, right? Before a prosecutor out in the field in San Francisco or Houston or somewhere does anything, they have to consult with OIA. There's another one that could be sort of a notice requirement. So before doing anything out in the field, you have to notify OIA. The requirement that's instituted when it comes to subpoenas for records located abroad is stronger than that, right? It's a prior approval requirement. So just to read it here, U.S. law in the form of mutual legal assistance treaties requires that the United States attempt to obtain records using the mutual legal assistance process prior to resorting to unilateral compulsory measures. So unilateral compulsory measure would be a subpoena, right? Therefore, all federal prosecutors must obtain written approval from the criminal division through the Office of International Affairs before issuing any unilateral compulsory measure to persons or entities in the United States for records located abroad. So look, I mean, as written, again, this predates AMLA, it predates this new section. But look, as written, it would seem to apply to that. And as far as we know, the public knows, there hasn't been an update yet. There might be. We just don't know. And it's certainly possible that, OIA, kind of asserting its jurisdiction, if you will, internally at DOJ, takes the position that, instead of issuing these subpoenas, just kind of on their own, we want to go through the AMLA process. We have good reasons for international comity for wanting to do that, at least with certain countries. It's possible, if you're asking me to kind of prognosticate and predict, I don't know for a fact, but I think there probably, will be some additional guidance specific to this provision of AMLA. Because again, go back to the first principles, government agencies like more power, and this definitely gives them more power. But that being said, it's, there's a lot out there to balance. Again, international comedy and things like that being one of the many factors. So we don't know is the short answer, but I wouldn't be surprised if we see guidance at some point in the future. And I also definitely wouldn't be surprised if OIA continues what is now a well-established kind of theme that's enshrined in the Justice Manual of having kind of a prior approval abilities and powers when it comes to foreign subpoenas. So there you have it.
So the way it's written now, every first year assistant U.S. attorney won't be able to subpoena banks all over the world. You know what I mean? Just because they feel like it would help their case, at least as it stands now.
I think that's right. I think that's right. I think there's a provision in the Justice Manual that would seem to apply to cutting a subpoena under the new law that predates the new law, but it still seems to bind AUSAs to seek OIA's prior approval before acting. So we'll see what happens, but at least right now it seems like that's still the case.
And, you know, it wouldn't surprise me, to the extent it was possible under the home country jurisdiction, that the potential for this statute might encourage some cooperation that might not have been there in the first place, might not have been there without this, as almost like it's the sword of Damocles over the correspondent relationship for those. Because for some countries, as you said, Deb, there's only one or two banks that have U.S. correspondent accounts, and they're vital. So it might encourage some intra-government cooperation that may have not been there before. I mean, again, I am totally just guessing, but knowing how these things work, even way back in the days when we were trying to get documents out of Switzerland at the SEC, you know.
Probably a good guess, though, Alma.
Yeah.
That'd be my guess, too.
Deb, there are some more like technical provisions that I think are important for people to really focus on. Do you want to go through those?
Sure. Well, I think there's another one that's pretty extraordinary in terms of record retention. And I know that sounds dull, but wait until you hear this one. Basically, for any U.S. financial institution that's covered by the law that has correspondent accounts in the U.S. for a foreign bank, the U.S. bank has to maintain records in the U.S. identifying the owners of record and beneficial owners of the foreign bank. Now, I don't know that everybody's got that information for correspondent banks in terms of who are the beneficial owners of the foreign banks. And obviously, you know, I'm not sure what one has to do if the bank's publicly traded and whether they'd really need to dig that deep or whether the usual beneficial owner exclusions would apply. But certainly it's something that's probably going to need to get peeled back. And they also have to maintain the name and address of a person who resides in the U.S. and has already been authorized to accept service of legal process for records for this section of the AMLA. So basically, I think that means that the foreign bank has to have an agent for service of process here in the U.S. that can get served quickly on this, which again may not be something that they all have just because they set up a correspondent bank account. And then again, in terms of the tight time frames, upon receipt of a written request from a federal law enforcement officer for the information that's required to be maintained under these record retention provisions, the covered financial institution in the U.S. must provide the information to the requesting officer not later than 7 days after the receipt of the request, which also depending upon what they're having to pull and where, you know, for any, I mean, I spent 10 years at a bank, right, which is actually where I started doing Bank Secrecy Act law years back. But pulling down records that aren't at your fingertips is not always easily done. And clearly part of the expectation here is that the bank needs to have thought through how to pull those records down within a 7-day period of time, you know, if one of these requests come in. So again, it sort of goes a little bit to needing to pre-think through how you would handle this if you get one of these notices, or if you've got correspondent banks, if your foreign bank gets a notice on it as well. And then actually, Alma and Patrick, I'd be interested because then you've got sort of interesting issues in terms of if this is sheer speculation, but if the U.S. bank is already a little iffy in terms of the correspondent bank account, you know, obviously there's circumstances under which they would have to close it, but, you know, one has to wonder whether it would cause the U.S. bank to think about whether they want to close it longer term or shorter term just for risk purposes. Again, nothing in the law that requires that unless the foreign bank hasn't responded and the U.S. bank has gotten that 10-day notice. But it is interesting to think about the practical implications of it.
Well, and it's so difficult for foreign banks to get correspondent accounts with U.S. banks just because the banks don't want to deal with the risk anyway.
Right.
This is not going to make it easier. I mean, I've had someone from a bank in the Caribbean say, I would show them my program. It's all really good, but no one will even talk to me, right? Especially the smaller banks. So I could see where this might lead to a further restriction or de-risking of correspondent banking
So I'm not sure about this, but I think what I'm hearing is if you're a bank and you want to do a risk assessment and you want to get some advice on how best to proceed given this new framework, you should call ALMA and you should call Deb. And
we'd be happy to help, Patrick. We'd be happy. We're a good team. We do this all the time, so we'd be happy to help. But yeah. It's some issues. So let's end on a
or
positive
you can call
note.
Patrick, or there's other competent attentions too.
Yeah, exactly. We got lots. Let's
usually
end
get
on
up on panels and go, here, give it to us.
let's end on a little positive note. Motions to quash. It is possible to have these subpoenas quashed.
It is possible, but again, it's got to be quashed in the U.S. District Court in which the investigation is going on, and the subpoena itself will tell you which U.S. District Court, so you're not having to try to figure out which one in a blind choice, which is helpful. But again, the law itself limits the powers to quash, and if it's merely on a privacy basis, the law specifies in the U.S. that is not sufficient. So, Patrick, I don't know if you got one of these. How would you attempt to quash it?
Well, I think you'd attack it again, and at this point, it'd be kind of a litigation of first impression or something like that. So I think you just go at it from every angle imaginable. If again, assuming they're reasonable, and then you have a client that wants that, and I think the overly burdensome angle, especially if under this kind of theory of third parties. I mean, again, think about what is being asked, right? That's another thing is, Deb, you've kind of pointed out some of these requirements are onerous, and some of them, assuming, let's say, the government, doesn't want to negotiate and they want to stand on the 7-day deadline or whatever other pertinent deadline might apply. I think companies, if not, getting an outright quash, banks and companies might have a leg to stand on and going to court and saying, look, I understand the statute says this, but as applied to these facts, as applied to what the government is seeking from this account and this relationship that we've had that may go back, a very long time, it's overly burdensome and it's too onerous on us. And again, maybe the court limits the subpoena, and maybe there'll be some reported case law out there in the near future. But I think it's never a bad idea if you've got a client who is facing something like this and facing uncertainty in a new statutory context like this, to sort of say, go whole hog and say this is too burdensome, and we're just going to fight it on those grounds and see what comes.
Well, it certainly is interesting. It'll be interesting to see how this develops and when it's used in it. Frankly, if we hear about it, I guess if the foreign banks just quietly comply, we won't hear about it. But there's a lot going on. Listen, I want to thank everyone who joined us today. For a more detailed look at the Anti-Money Laundering Act of 2020 or the Corporate Transparency Act that dealing with beneficial ownership reporting, we have webcasts on those topics that are available on the Guidehouse and Pillsbury websites for viewing at your leisure. But again, we really do thank you for joining us today. Deb and Patrick, this was a lot of fun. I'm looking forward to our next one. We'll have to come up with a good topic for that. And we hope you'll join us for that. Let us know if you have a suggestion.
Next one may be AI under the law.
Yeah,
we'll
that would be great. That's a focus.
Yep.
Yep.
Well, thank you, everybody.
Bye.
Thank you.